Below is realistic, court-ready dismissal language, modeled on how a federal district judge would actually write it. This is not softened, and it tracks how judges dispose of complaints like this in Pergite 1983 pro se cases. I'll structure it the way an order granting motions to dismiss would appear, with grouped rulings rather than count-by-count repetition, because that's how courts do it. Order granting defendants' motions to dismiss. Introduction. Plaintiff Rex Fredrickson, proceeding pro se, brings this action asserting 57 causes of action under 42 U.S.C. Part 1983 and 1985, various criminal statutes, state tort theories, and constitutional provisions arising from alleged encounters with private individuals and local government actors. Plaintiff seeks in excess of $42 million in damages. Defendants move to dismiss under Federal Rule of Civil Procedure 12b-6. For the reasons set forth below, the motions are granted. 2. Legal standard. To survive a Rule 12b-6 motion, a complaint must allege sufficient facts, accepted as true, to state a claim for relief that is plausible on its face. Ashcroft v. Iqbal, 556 U.S. 6662, 678, 2009. Courts are not required to accept legal conclusions, conclusory allegations, or unwarranted inferences. Bellattle Corp. v. Twombly, 550 U.S. 544, 555, 2007. Although pro se pleadings are construed liberally, the court may not supply factual allegations or legal theories on a plaintiff's behalf. Hall v. Bellman, 935 F. 2B 1106 10, 10th Sir, 1991. 3. Threshold deficiencies applicable to all counts. A. Failure to plead specific facts, dates, locations, or actors. Across all counts, plaintiff repeatedly alleges incidents, armed confrontations, and retaliatory conduct without identifying specific dates or times, precise locations, which defendant engaged in which conduct, what conduct was unlawful, or how such conduct violated a clearly established constitutional right. Such vague and conclusory pleading fails Rule 8 and independently warrants dismissal. Robbins v. Oklahoma, 519 F3D, 1242-50, 10th Sir, 2008. B. Lawful conduct cannot support constitutional claims. Plaintiffs' claims are premised primarily on defendants' lawful activities, including open carry of a firearm under Colorado law, public filming and live streaming, verbal speech in public forums, and presence in public places. Lawful conduct, without more, cannot constitute a constitutional violation. Pauls v. Thomas, 718 F3D 1210, 1226, 10th Sir, 2013. See no state action by private defendants. Defendants Archbell and Thayer are private individuals. Plaintiff fails to plausibly allege joint action, conspiracy, or coercion sufficient to transform private conduct into state action under 1983. Lugar vs. Edmondson Oil Co., 457 U.S. 920-927, 1982. Conclusory allegations of coordination and retaliation are insufficient. Tonkovich vs. Kansas Beat of Regents, 159 F. 3D 504, 5533, 1998. 4. Dismissal federal constitutional claims. A. First Amendment retaliation, counts 37, 38, 41, 5, 48, 51, 52, 57. Plaintiff fails to allege facts establishing 1. Constitutionally protected activity, 2. Adverse action that would chill a person of ordinary firmness, 3. A causal connection between the two. Mink vs. Knox, 613 at 3D 995, 1000, 10th Sir, 2010. Public criticism, filming, speech, and lawful presence do not constitute adverse action. Plaintiff's own publication of his litigation and online disputes further defeats any chilling effect theory. These claims are dismissed with prejudice. B. Substantive due process, counts 34, 39, 46, 55. Substantive due process protects against only the most egregious, conscience-shocking government conduct. County of Sacramento v. Lewis, 523 U.S. 833, 8 and 46, 1998. Plaintiff alleges no conduct approaching that standard. Psychological distress arising from lawful encounters and online speech does not implicate substantive due process. Counts are dismissed with prejudice. See procedural due process / Matthews v. Eldridge, referenced generally. Plaintiff fails to identify any protected liberty or property interest of which he was deprived without adequate process. Allegations of harassment or enforcement dissatisfaction do not trigger procedural due process protections. Tigan vs. Renfro, 511 F 3D 1072, 1080, 10th Sir 2007. All procedural due process theories are dismissed with prejudice. D. Equal protection, counts 53. Plaintiff fails to allege facts showing he was treated differently from similarly situated individuals or that any differential treatment was motivated by discriminatory intent. Kansas Penn Gaming LLC vs. Collins, 6556 F 3D 1216, 10th Sir 2011. Conclusory assertions of unequal enforcement are insufficient. Dismissed with prejudice. E. Eighth Amendment claims. Referenced in 42. The Eighth Amendment applies only to criminal punishment following conviction. Plaintiff was not subjected to punishment, incarceration, or sentencing. Enforcement actions and private speech do not implicate the Eighth Amendment. Ingram vs. Wright, 430 U.S. 651, 664, 1977. Any Eighth Amendment theory is dismissed with prejudice. V. Statutory claims. A. 18 U.S.C. Prop 1513, counts 37, 44, 51. Section 1513 is a criminal statute that does not provide a private right of action. Shanigan v. Cahill, 58 F. 3B 106, 109, 4th Sir, 1995. These counts are dismissed with prejudice. B. Civil Reel Count 56. Plaintiff fails to plead an enterprise, continuity, predicate acts, or injury to business or property. Monetized live streams and online speech do not constitute extortion, wire fraud, or racketeering. Tal v. Hogan, 4533 340 1244, 10th Sir, 2006. Dismissed with prejudice. Stash C. Package 1980 conspiracy claims counts 35, 41, 48, 53, 57. Plaintiff fails to allege class-based discriminatory animus, an essential element of Package 1985-3. Griffin v. Breckenridge, 403 U.S. 88, 102, dismissed with prejudice. V. Municipal liability, Monell. Claims plaintiff fails to identify a policy or custom, deliberate indifference, or a causal connection between municipal policy and alleged harm. Allegations of failure to act on complaints do not establish Monell liability. City of Canton vs. Harris, 489 U.S. 378, 385, 1989. All Monell claims are dismissed with prejudice. 7. State law tort claims A. Intentional infliction of emotional distress, counts 42, 49. Lawful speech, filming, and presence in public places do not constitute extreme and outrageous conduct under Colorado law. Coors Brewing Co. v. Floyd, 978 P2D 663 6666, 1999. Dismissed with prejudice. B. Negligent supervision, abuse of process, counts 36, 43, 50, 54. Plaintiff fails to allege duty, breach, or misuse of process for an improper purpose. Allegations contradict lawful enforcement authority and are conclusory. Dismissed with prejudice. 8. Cumulative injury, medical deterioration, count 55. Plaintiff's health allegations are speculative, conclusory, and unsupported by facts establishing causation. Courts do not recognize cumulative constitutional injury theories based on lawful conduct and private speech. Dismissed with prejudice. 9. Leave to amend. Because plaintiff's claims fail as a matter of law and cannot be cured by amendment, leave to amend is denied. Brereton v. Bountiful City Corp. 434 F3D 12 and 13, 12 and 19, 10th Sir, 2006. X conclusion. Defendants' motions to dismiss are granted.